This is Barry Zalma speaking for Zalma's Insurance Fraud Letter, Volume 26, Issue Number 2 for January 15, 2022. This issue will begin with how a convicted fraudster loses his appeal in a case called The People of the State of New York versus Kevin A. Ashby. The Supreme Court of New York Fourth Department, after he was convicted, dealt with an appeal that the jury verdict of insurance fraud in the third degree and attempted grand larceny in the third degree. Ashby contended that the indictment was jurisdictionally defective. The failure of the first count of the indictment to recite all the elements of the crime in full. However, the appellate court found that the failure did not constitute a jurisdictional defect because the court specifically referred to the applicable section of the Penal Law. Although the defendant further contended that each count of the indictment was legally insufficient because the counts did not set forth sufficient factual allegations, he failed to preserve his contention for the court's review at trial. Ashby also contended that count 1 of the indictment was impermissibly amended, and that also failed because, contrary to the defendant's contentions, he was required to preserve that contention for appellate review. Although past cases of the court have not required preservation of such a contention, defendant failed to preserve his contention for review, and the court declined to exercise its power to review. Fraudsters, people who commit insurance fraud, are just amazed when they are arrested, and even more so when they are convicted, and they will file an appeal automatically, regardless of how inadequate the appeal. In another case where an arrest warrant issued fairly defeated a malicious prosecution suit after 2 people accused of insurance fraud had their fraud case dismissed by the court, filed a malicious prosecution action against the police officer who arrested them. Now, a fire had destroyed the plaintiff's residence and all her personal belongings, and the plaintiff notified the defendant of the fire and made a claim pursuant to a policy she had with State Farm that extended coverage and made a payment as much as $239,200 for loss of the residence, but did not issue any payment for loss of her personal property. Defendant Allen, an investigator of the Georgia Office of Insurance and Safety Fire Commission, submitted a warrant application to the Magistrate Court for Grady County, Georgia, for plaintiff's arrest. The application stated plaintiffs collected insurance money for living expenses that were not legal, made false statements to the insurance company, and when they made their first appearance after being arrested and were booked, the Grady County magistrate dismissed the criminal warrants for lack of evidence. And then, adding insult to injury, they sued the police officer as well as their insurance company. The police officer, of course, asserted appropriate immunities, and the case was eventually dismissed. You could read the full article at Zalma.com by clicking on the link to Zalma's Insurance Fraud Letter. The issue also deals with a claim school Incorporated's insurance education available to anyone who subscribes, and how a workers' compensation board improperly ignored evidence of fraud. and after the Workers' Compensation Board ruled, among other things, that the application of Everest National Insurance Company was required to pay benefits, the insurer appealed seeking review of the decision because they didn't insure the person claiming benefits. In the matter of the claim of Michael Salinas versus Power Services Solutions, LLC, the Supreme Court of New York, Third Department, was faced with a decision of the appellate court, who found that a party seeking review of the workers' compensation decision is required to file an application for review with the board within 30 days of the filing of the decision. The board is afforded broad discretion to accept or reject such application as untimely, and absent an abuse of discretion, the board determination will not be disturbed. However, in the view of the appellate court, the board abused that discretion. The early stages of the claim were notably protracted, and Everest was brought into the fold a year and a half after the claim was filed, missing the first 6 hearings and all of the investigations regarding claimant's actual employer and issues of coverage. Correspondence sent to Everest, including a February 2019 decision, continued to facially reflect that Kingdom and Star were responsible for the claim, not Everest. It was only in the middle of a paragraph on the 2nd page of the decision that Power Services is named as the employer and Everest as its carrier. The board did not update its own file to reflect the proper carrier until about 1 month after the decision, and although that may have given Everest several days in which to file a timely appeal, there was no indication. No insurer should be abused by a workers' compensation appeals board who ignored its own error when holding Everest to provide benefits to a person, even though it was clear that it was the victim of an insurance fraud. The alleged injured employee was charged with fraud in a very public manner, and the pleadings presented to the Everest by the board deceived it into believing it was not involved. The board's abuse of discretion required a reversal and allowed the board to correct its answer. You can read the full article at Zalma's Insurance Fraud Letter by clicking on the link at www.zalma.com. There's also a lengthy article on a proposal written by me to defeat insurance fraud, which is also backed up with a lengthy video explaining the proposal and why things like a QI-TAM action can work to help defeat insurance fraud. In addition, insurers must be proactive with regard to insurance fraud and not spend their time waiting for the state to do something to arrest an insurance criminal. By being proactive, the insurer will establish that it is ready to spend millions to defend against fraud and refuse to pay tribute to anyone, especially a fraud perpetrator. Setting up such a company policy will go a long way to reduce insurance fraud attempts against the insurer. Fraud perpetrators will move from that proactive insurer to another. Those insurers who do not have such a corporate policy will find more attempts at insurance fraud and will be encouraged to take on the aggressive anti-fraud provisions. These include 1. Publishing to the insurance buying public that it is the insurer's incorruptible opinion that it will never pay what it believes to be a fraudulent claim. 2, it will retain counsel to defend the insurer. 3, it will instruct defense counsel that the insurer expects counsel to take the matter to trial. 4, it will instruct defense counsel to aggressively defend the lawsuit. 5, it will instruct defense counsel to conduct every needed discovery immediately without courtesy to the other side. 6, instruct defense counsel to depose every insured, every witness, and every expert consulted by the insured as soon as possible after the filing of the lawsuit. 7, instruct defense counsel to move the trial court for orders limiting the actions of the plaintiff, including but not limited to motions for summary judgment, motions to compel discovery responses, motions in limine, and any other motion available to limit the case. 8, instruct defense counsel that he or she has no authority to settle or even consider negotiating a settlement. 9, instruct defense counsel to advise the policyholder's counsel that the case must go to trial and there will be no settlement discussions. 10, instruct defense counsel to advise the court that because the insurer believes it was defrauded, it is against the insurer's corporate policy to pay anything to a fraud perpetrator. 11, instruct defense counsel to provide no courtesy to policyholder's counsel. 12, if after trial there's an adverse judgment against the insurer, instruct counsel to immediately file an appeal. And 13, if the court finds the insurer owes nothing as a result of the fraud, the insurer should consider litigation against the insured for damages, including punitive damages for fraud and or malicious prosecution. The January 15, 2022 issue also includes a listing of good news from the Coalition Against Insurance Fraud and their listing of insurance fraud convictions, an article about how an insurance fraud conviction was affirmed by the Court of Appeal in Utah after finding that the person accused had attempted fraud against an insurer, even though the fraud was fairly small. Although major insurance frauds are ignored by prosecutors, in this case a $1,500 to $2,000 fraud was tried. The defendant was properly convicted and will be appropriately punished because he was ignorant enough, with his lawyer present, to tell an investigator that he was not injured in any of the multiple accidents with which he was involved, and received chiropractic treatment that he believed to be a right, even though there was no physical reason for the treatment. Taking this case up on an appeal is an example of why states are loath to bring insurance fraud cases to trial, because the expense of the trial and an appeal far exceed the amount taken in the fraud. However, if other states emulate Utah, any prosecution and conviction will deter others from attempting fraud. The newsletter then lists convictions for health insurance fraud across the United States and convictions for other than health insurance fraud, including a Louisiana woman who was the 30th guilty plea in a staged auto crash case, and a pastor who is ordered to spend 15 weekends in jail for insurance fraud, among others. Finally, there is an article concerning excellence in claims handling, a series of video presentations and text on insurance claims available from Claim School Incorporated, and a listing of all of the last 10 Zalma on insurance claims blog postings. Thank you for your attention. And please subscribe to Zalma's Insurance Fraud Letter so that you can receive notice of these important newsletters every month that they are published. Thank you again for your attention.